Hey, everybody. Thank you very much for joining us. This is our first podcast, our first webinar. So if we fumble a bit, if we curse too much, if we laugh too much, we say the wrong thing, please forgive us. It's our first shot. Some of you may know me. My name's CJ Rosenbaum. I'm one of the founding partners of ROSENBAUM FAMULARO. I also have my fantastic, world-renowned, most awesome business partner in the whole world, Anthony Famularo, on. And also Rob Segall, who's one of our top lawyers here. He's an associate attorney, and he handles our arbitration practice. He is the managing attorney for all our arbitrations. And what we're going to be talking about today on this webinar are arbitrations. So if we can, Anthony, why don't you introduce yourself a little bit? And then Rob, why don't you introduce yourself? And then we'll get this, our very first podcast / webinar going.
Okay. My name's Anthony Famularo. Along with CJ, I am the one of the founding partners here at ROSENBAUM FAMULARO. I'm mostly responsible for the day-to-day work, plans of action, brand protection, arbitration. With the arbitration, CJ, Rob, and I work together on those matters. And yeah, sorry.
All good. Rob, how about you? Tell the people listening, because a lot of people around the world know me, and a lot of people around the world know Anthony, but we've kept you hidden. We've kept you in the closet. So tell our viewers who you are and a little bit about yourself.
Well, like CJ said, I mostly handle the arbitrations, but I've been with the firm for just about 3 years now. So they definitely, I guess, have kept me hidden, as CJ has said. But it's a really great place to work. The arbitrations are always exciting. Amazon's lawyers always tend to have a trick or two up their sleeve. We'll get more into it in a bit.
All right. What I also want, I want you guys to have some of the background about us personally. Okay. Now, Anthony and I met as this practice was developing. I needed help covering my old stuff. I used to do a lot of trials. I used to do a lot of divorce cases, and I needed help covering that. So I put an ad on, of all places, on Craigslist, and into my life comes walking Anthony Famularo. And within weeks, I knew that I'd become blessed with an absolute genius, aggressive, just a really great lawyer, and he became a fantastic friend of mine. That's how Anthony and I met. And with Rob, our first law student to help with research was this woman named Nicole Kulaga, who came in and we hired her. And then she said, I have a couple other people. You have to meet this guy named Rob. And then in came Rob. So that's how we all met. And now we are partners. Now we are business associates. And we're also really close friends. And what we pride ourselves here is really having a family atmosphere where we back each other up. I mean, just a week ago, Rob was learning to ice skate with my 6-year-old Max. I see Anthony and his wife all the time. It's just really a fantastic team that we have here. All right, Rob, why don't you start by describing, what an arbitration is and why sellers end up there?
Okay, so arbitration is very similar to court, but it's supposed to be faster and cheaper. Sometimes Amazon's lawyers try to prevent that from happening, but we do everything we can to make sure it stays fast and as inexpensive as possible. But essentially, arbitration is where you end up when you get stuck in a cycle where Amazon is not listening to you. You're sending in plan of action after plan of action, and you're getting the same bogus, bullshit, generic responses. It's when you're appealing to the escalation teams and nothing else is working. It's when you want to take the decision out of Amazon's hands and just take it to that next level and try to, not fuck up this podcast.
I got to say, I was waiting for you to say those words, that we take decision making out of Amazon's hands. So I'm really glad you said that. Now, the pre-game, the pre-arbitration matters are really handled by Anthony Famularo, and I don't think there's anybody else on the planet that knows more about plans of action, appeals, and Bezos escalations than Anthony. So Anthony, why don't you describe a bit of sort of the background of how a seller, ends up in arbitration?
Yeah, I mean, I'd agree that arbitration to me is the last resort, and you don't want to kind of go there until you've tried to exhaust all the internal appeal options for whatever your issue is. With sellers, usually you're going first to the seller performance or the notice dispute team, whether you're appealing a buyer complaint or an intellectual property complaint from another rights owner or company. Um, there is an escalation team you can go to. Sometimes, contacting seller support can help get your plan in the right hands. But what we do most day in and day out is try all those internal measures first, because even though arbitration is supposed to be quicker than court, it's really a last resort in the Amazon level. And um, there's nothing faster than just successfully getting through Amazon's internal appeal procedures. It's the fastest way to resolve your issue. Even when we take things to arbitration, we still try a couple appeals during the process sometimes, because it works. We've had arbitrations, get tied up unfavorably, and during it we'll win with an appeal, and it'll be so I really think, like, we deal with all the pre-arbitration measures, but they really should be exhausted before you even think about arbitration.
So if you're a seller out there and you've used some other service, I don't care if they're located in Texas or Boston or the UK, wherever they might be, whatever personality you chose, if they struck out and now you're thinking you have to go to arbitration, if you hire us, we're still going to give another swing at the plate to try and get you reinstated, because while arbitration is faster and cheaper than going to court, it's certainly slower than a plan of action. And if your plan of action or your appeal or your Bezos escalation is successful, there's no need to go to arbitration, or you could just pull the plug because you've got your money back, you've got your account reinstated, and then you don't need to go through that. So Anthony and his team, and if you look at us right now, you see all different backgrounds. The way we set this up today is Anthony's in his conference room. Rob is sitting in Brett's office, who's our director of client relations, and I'm in my office, just so we don't have the feedback. But as far as I am aware, we are the only company, the only firm out there where you actually have a whole team of people working together in the same space. We do not work out of a P.O. box, and you know who you are that I'm talking about, in a UPS store. We have a full-blown team here in beautiful downtown Long Beach, New York, which is what you're seeing behind Anthony, which is the town where most of us live and that work here. All right, Rob, let's get into how, if once the plans of action and the escalations, if it all strikes out and Amazon is saying, screw you, we're not giving you back your money, screw you, we're not reinstating your account, what's the first thing that we do? What's the first document that we put together in order to start the process going?
So that's called a demand for arbitration. And it's a bit different than a complaint that you would file in court in the sense that it's a much simpler document. The real purpose of a demand for arbitration is just to put the AAA, the American Arbitration Association, and Amazon's attorneys on notice that we're bringing an arbitration claim against them, and simply provide the legal claims that we will bring, but we'll emphasize and flesh out later in the briefing process. So the demand is what starts the process, lets the AAA know that we need to be provided an invoice for our filing fees, and that we can officially start the arbitration procedure.
Now, one of the cool things that we're working into our system is that if your arbitration is for up to $10,000, if Amazon has seized, $10,000 or less, we're going to help you do this yourself. And a lot of the work is already done in the plan of action. So Anthony, how can we use what a seller's already put in their plan of action or their escalations in order to do the demand for arbitration? How does it all work into play?
I mean, and like I said earlier, that we still kind of try to appeal when we're hired for arbitration. It's good because it summarizes the case, like you're saying, and it shows, the point is, when you arbitrate, you have to show what Amazon did wrong. So it's important to have at least one final summary appeal that shows you gave them everything they asked for, and it's on them that they didn't resolve it. So when you do that comprehensive appeal, you're taking the measures you gave them. If it was an IP complaint, why it was a baseless IP complaint. You're taking the substance from that appeal. It's going to be in your demand for ARB, but at the same time, the demand for ARB doesn't have to have every fact in it. That can all come out through the arbitration process. The main point in the demand for arbitration is that you provided everything to Amazon that was requested. That they, even though you gave them everything you were supposed to, they've still failed to properly act, and what relief you're entitled to because of that. Those are the big things in the demand. The rest of the specifics don't have to be there, but that overall case theory, you're gonna gain that from those last appeals.
So if you come to us and you talk to us about it, you're going to work with Rob, and I do. I think Rob is a remarkable young lawyer. He does a really great job. But Rob, in some way, you're really taking Anthony's work, right, from doing the plans of action or Anthony's team's work to draft your demand for arbitration. I mean, you're really relying upon the plans of action and Anthony's team, and you're doing that demand.
Well, that's correct in a sense, CJ. So one of Anthony's favorite things to say is that Amazon is consistently inconsistent. So unfortunately, a lot of the cases that end up in arbitration are cases that seem really, open and close. That they're really straightforward, and that Amazon's really dropped the ball. So when we go through the arbitration process, a big thing that happens once we file the demand for arbitration is that those attorneys at Amazon and the Amazon employees at a higher level are being put on notice of this bullshit that's going on, and seeing like, hey, this guy from the middle of the country who's just trying to run his shoe store can't sell his shoes in the Christmas season because Amazon's algorithm flagged his invoices that they're manipulated, and it's clearly bogus claims. So
yeah, we deal with a lot of bullshit from Amazon. We deal with it very, very successfully. Also, just an aside, if you're looking behind Rob Segall, and you're going to get to know, Rob and I work together every day, all day long, and I know it's a blessing. Rob's not sure if it's a blessing or a curse, but if you look at that killer artwork behind him, that is a painting done by my 6-year-old boy, Max. The one below it was done by my stepson, Finn. And I'm sorry, listen, my blood gets top level, and then my stepson goes below that. But it's great artwork behind Rob. Okay. All right. Let's talk about why we are a great team together and how our skills sort of interact. And I don't want this to be too much of a sales pitch, but I think people need to know how we come together when Amazon tells them to go screw themselves, tries to seize their money and seize their inventory, all of our different skills that come into play. So you heard Anthony talk about the plans of action, his team who does that, okay? And Rob, talk about how a detail-oriented person you are, okay? You're everything about you. We want people to get to know us.
Well, CJ, there's a lot to know, so I'm not really sure what exactly you want me to let everyone know about right now. Something everybody loves to tease me about is how neat and clean I love to be, and if someone's sneezing next to me, I might run for the hand sanitizer or the Lysol or something and start dusting or whatever. But in terms of the law, my background is mostly in intellectual property. That's what I focused on in law school. I took every IP class that my school had to offer. I participated in the IP concentration.
That's exactly it.
Yeah.
All right, speak over you. That's exactly what I wanted you to hit. And listen, the personalities of our personalities, I think, are part of what makes us great. Okay, Anthony knowing every single issue as it comes down the pipeline because he's handling dozens of plans of action a day through his team of college-educated paralegals. Rob being a neat freak and detail-oriented is fantastic. Okay, it definitely complements me because my history is as a trial lawyer. Okay, I was a plaintiff's car accident, medical malpractice, employment trial lawyer before getting into this space. So Rob gets all the details together. Anthony knows exactly what's going on within Amazon. And then I'm able to take that all together and present it in a persuasive manner. So that's kind of some of the things that we do at the skills that we all bring together in terms of doing the best job for you and covering sort of all the bases. So if you're not using someone who can cover the 3 different, knowing the interior of Amazon, what's going on, up to the minute knowledge, like Anthony, someone super detailed like Rob, the neat freak helps because there's nothing in your file that Rob misses, absolutely nothing. I mean, he's fantastic at it. And my ability to ramble on and on like I'm doing right now in a persuasive manner. Okay. All right. So Anthony, why don't you tell us a bit about a couple of case studies where, the seller just struck out. I mean, we don't win every case and we don't tell people we do. And that one website out of the UK where they claim 100% success is total bullshit. Okay. So tell us about a couple of case studies where, we had to go to arbitration.
Yeah, I mean, Rob referenced earlier, lately Amazon's been suspending sellers, alleging that they've forged or manipulated documentation. Like with most Amazon suspensions, there's definitely a layer of it that's somewhat bot triggered rather than rather than like human centered. And we had a seller get suspended, money seized, no responses to any appeals from either any team, not even a chance to explain what the error was with Amazon. And recently, we filed arbitration, and Amazon's attorneys put a settlement back on the table to reinstate, once it went before them, to reinstate, to return the money, to continue selling, and to rectify everything. But whatever was flagged internally didn't matter how good the appeals were. It was just not in front of the right people. And so we had to arbitrate to resolve that one. Haven't had to do that for every suspension like that, but for that one, no team was listening, and we had to file to prompt Amazon to actually look at the case.
Hey, let me interrupt this flow for a second here. So if you're watching this video, what we're going to do at the end is not only have you now learned a bit about us and our personalities, we are going to tell you about Amazon's lawyers and what we've come to learn about them and their personalities. All good stuff. But again, as a trial lawyer, okay, when I was doing nothing but trying cases, what I learned is that you need to manipulate everything in the room. Your adversary, the jury, your witnesses, the judge, even the court officers, you learn how to play to make your case like a persuasive package, okay? And it's constantly shifting. So we do the same thing with Amazon's lawyers, and our game plan shifts based upon which one of their lawyers is assigned to the case. So stay tuned to the very, very end, and then we're going to tell you the inside information about Amazon's lawyers who oppose all these cases. It's the same firm out of Seattle who handles all the arbitrations when Amazon seizes your money, refuses to reinstate your account. So stay tuned for that. We're going to tell you all about Amazon's lawyers at the end. All right, Rob, so take it from where Anthony left off.
Sure. And I think it's important that to emphasize the language that you used just now. You said we had to arbitrate, and earlier you emphasized that arbitration is a last resort. So I don't mean to kick it back to you right away, but can you just explain maybe like why you think it's so important to consider arbitration as a last resort, and what could be some of the pitfalls if a seller tried to rush into arbitration when it wasn't ripe?
Yeah, to me, you can only arbitrate with Amazon under the agreement you agree to as a seller, the BSA, the Business Solutions Agreement, and in that clause, there's in addition to the arbitration.
Let me jump in here, and
Okay.
we're going to get a better flow, okay? And I'm going to try not to interrupt. Most sellers don't even know what the BSA is, okay? And these events all over the world, people have terms of service, participation agreement, and you're referring to the wrong document, okay? If you have never heard of the Business Solutions Agreement, Google it. Business Solutions Agreement and Amazon, that's the contract you're under. So anyone who's talking about the terms of service and the participation, they don't know what the fuck they're talking about, okay? Okay, Anthony, tell them about this contract, the good and the bad, and also we fight the terms of the contract all the time, which we're also going to get into.
Yeah, so arbitration and the rest of your agreement and the rest of your business with Amazon goes under this agreement. And it's very pro Amazon. So if you're arbitrating, you're basically saying under this agreement, Amazon failed to fulfill its obligations. But unfortunately, everything, including just the existence of the agreement, is in Amazon's favor. It says it's at will. In other words, they don't need a reason. They can terminate you for any reason at all. It doesn't mean they do. They still settle arbitration cases, but technically the agreement is just written so in their favor that the quickest way to try to get up is still to try internally. You really don't, when you're arbitrating, you're still taking a calculated risk that the risk of arbitration is still worth it, because Amazon's final decision, even if it's somehow upheld, just you can't let it stand, and that's why you have to arbitrate. But you can go to arbitration and you could get a decision that says, no, they did nothing wrong under their agreement, even if they refuse to reinstate you. You may get, if you're fighting over inventory and funds, you may get that back if you can show, they didn't have a good basis for holding it. But the big thing with reinstatement is the contract is at will. So you really, really need to exhaust all those internal procedures if you're trying to appeal for reinstatement.
Now, I want people watching this to know that we have won. Even though the contract says that Amazon can cut your legs off at will, we have won that. We've had arbitrators tell Amazon, even though the contract says they can't do it, you have to reinstate. Okay, so you can still win that argument. And we're also challenging the contract. And as we do more and more arbitrations, our game is getting better and better. Amazon has also increased their game a bit. But even though the contract says it's at will, we have won cases where the arbitrator has told Amazon, reinstate this account. And also, Anthony mentioned settlements, okay? Many of the cases settle with reinstatement or an amicable restitution of your money, a return of your money, or they return your inventory, or they try to return your inventory and it shows up broken, then you get money. So even though the contract says it's at will, and Amazon argues that in every single case, we have won that issue, and we've gotten sellers reinstated, and Amazon complies with the orders. They do. Rob, what do you want to add to this conversation? Smile a bit more, even when you're not talking, okay?
Well, you seem to have everything to say all the time. You love these videos so much, man. I mean,
what I also love, Rob and I bust each other's balls every day, not all day long, because Rob works very, very hard, as do I. But that we have a great working relationship.
Yeah, both. I love spending time with CJ outside the office. Also, I do consider him a friend. He's a great guy.
The contract. Back to the contract.
We're talking about the contract. So, like CJ said, we attack the contract all the time. There's a lot of provisions in there that are, like Anthony said, totally one-sided. In our demands for arbitration, we do kind of highlight a list of them. One of the more ridiculous things that we see is, if Amazon determines that you owe them money, one of the terms of the contract allows them to take that money from you in any way they seem possible, including running your credit card that they have on file. So we've seen some pretty ludicrous things happen because of the way the contract is drafted. And, as an Amazon seller, like CJ said, if you haven't seen the BSA, the Amazon Services Business Solution Agreement, Google those words and read it from start to finish, please.
Also what you're going to see there at Amazon, they can seize your money. And in one of our cases, Amazon's arguing they should be able to keep our clients. It was like $50,000. They should be able to keep that 50 grand because they want to put it towards their 200 million they use to fight counterfeits. And that's not in the agreement. And they totally lost that argument. Also, the more ludicrous shit that they argue, we're compiling that. And eventually we're going to challenge the whole agreement in federal court. We're waiting for the right case to do that, but we're picking away. And as Amazon argues, just ludicrous things that how you should pay for like their counterfeit program when they're making $1 gazillion. Okay. We win that. And we just won that like a week ago. And I think the check just arrived, right?
Yeah. It's sitting on my desk waiting to get mailed to the client.
So we love getting checks from Amazon. The bigger, the better. All right,
Nobody
Rob,
loves it more than you, CJ. Nobody.
All right, Rob, keep going. So we're fighting the contract. Talk about this theory, this unconscionability, substantive unconscionability and procedural unconscionability. What do those big $9 words mean?
Well, like you guys have been saying, it basically means that the contract is so unfair that it should be declared unenforceable. So we both attack the contract in its entirety, but we also attack the certain provisions that we were talking about that are so individually unfair. One of which is the fact that the contract is at will, but in addition to being at will, it limits any other sort of relief that might be in your favor. So the fact that the contract doesn't allow sellers to get reinstated, doesn't allow sellers to get their money back, cuts their legs off and their ability to earn money, and then all the data and information remains in Amazon's possession is so one-sided and so unfair that we compile all the evidence we have in relation to our specific client's facts, tied with that that information about the contract and just use it to try to slaughter Amazon in front of the arbitrator and kind of make the situation of the facts and the story outweigh the law as it's written in Washington.
Yeah.
Also what you'll see in that contract is that it's internally inconsistent. Okay, the contract says that the arbitrator can do anything a judge can do, but then it says you can't do anything, and then Amazon makes these ludicrous arguments. So Anthony, I apologize, I spoke over you.
It's okay. I'll remember it in like a second.
All right, so you have this contract that says Amazon can screw you. They can keep your money, keep your inventory, steal from you left and right. They don't have to do anything at all. Then there's another provision in the business solutions agreement that says that the arbitrator can do anything a court can do, which includes overriding the contract. Okay, so look at the contract. That's really your agreement. And just know that there are significant legal arguments to override portions of the contract, and the arbitrator can do whatever he wants, and there's no appeal. So it's really an act of persuasion. You're trying to persuade that arbitrator to reinstate your account, to give you back your money, to send you back your inventory. Now, Rob, we had a case where Amazon was supposed to return the inventory, right? And what happened in that? Were they able to return the inventory?
I'm not sure which case you're referencing. Was this the case with the Gaylord boxes?
Yes.
I believe Amazon mishandled the inventory so severely for such a simple mistake that it cost our client hundreds of thousands of dollars. And that was one of the instances where we received a big fat check from Amazon to send to our clients. And CJ had the same smile on his face he does right now. So, inventory issues, as long as you have your documentation and, evidence in a line, they're usually much simpler to resolve. That's where the detail orientedness is definitely helpful, showing that you have documentations from when you shipped it to when Amazon received it, how long it was there, what condition it was in, and all those things makes it very easy to present the case to the arbitrator, or even just for Amazon's attorneys to see that maybe a settlement is what they should offer rather than continue to fight such another bogus claim.
I always loved when big checks came in when I was a personal injury trial lawyer and when I was representing victims of sexual harassment and age discrimination, because I would get a piece, okay? And I was so psyched. Immediately that check arrived and I figured out my third. That's not the case anymore. We charge you guys flat fees, okay? Flat fees or hourly if it's going to be a real prolonged case. So the check we received, that's going all to the client. And it's great. I mean, it's great. David versus Goliath. We love beating up Goliath, okay? And it's just great. But yeah, every time I see a check on Amazon coming our way, I'm stoked for the whole day. Anthony, do you want to add to that?
Yeah, I mean those are the best wins where we can at least make the client whole there, or in the cases that we're actually able to show injury, because the law is so anti-sellers. It's the contract is black and white, at least not the law, but the text of the contract is so anti-sellers. It's so black and white that when we can win on the facts and we can persuade that arbitrator, it's a great, exactly. You're on cloud nine for the whole day because it's a really great win. It just shows that it's not, even if the contract's at will, you're not. It's an uphill battle, but you're not done if you have to arbitrate. It's worth the fight.
I mean, like Rob said, arbitrations, you take the decision making out of Amazon's hands. It doesn't mean you're going to win every time, but you take the decision out of their hands. You get your day in what is very close to being in court, and it's cathartic, and we also win. And taking the decision out of Amazon's hands is super, super empowering. All right, I want to go to one more case study, and then again, stay tuned because we're going to talk to you about the people and the personalities of the lawyers on the other side. So, Rob, I'm shooting from my brand new MacBook Pro in space gray. Does that trigger a particular issue, particular obstacle that we were able to overcome in a recent arbitration?
CJ, you've triggered me. I'm so triggered. No, but seriously, yeah. Another recent case we had, just to show that it is ludicrous to say that Amazon can hold your money, or what we think amounts to seize your money at any time for any reason, is totally bullshit. In another case where, our clients' invoices were supplied to Amazon for some Apple products. Space Gray on those invoices was spelled SPASE. So you guys can think about that and decide what that means to you. I'm not going to say what our client was or was not up to. However, in that case, we were still able to recover the money that Amazon essentially stole from our client, which was upwards of $50,000. So again, it was a huge win because we were able to get the money back to our client, but we were also able to shove a decision up Amazon's ass when they're trying to bring these again ludicrous claims that, oh, we need our clients 50 grand to support our counterfeit programs and whatnot. Definitely a big win there, and something that we can look back and kind of laugh at them on.
Yeah, it was just great. It was just great. They couldn't beat us even when space was spelled wrong. And I got to think that Apple knows how to spell Space Gray. So I think that was great. All right, let's talk a bit about the personalities of the lawyers on the other side. And I'm going to start, okay? The partner at the law firm, we're just going to use first names here. His name is John. He is a super, super bright guy. He's a very good lawyer. He's a worthy adversary. And we also get along pretty well. I mean, we try and kick each other and beat each other's heads in during a case, but ultimately he's a really good and smart guy. And he was brought up on a ranch in Montana, and I grew up here in Long Beach, New York, which is a suburb of New York City. And he was telling me his life experience included castrating bulls on his family ranch. And it just turned my stomach how they feed him in and slice him off. And he goes through this whole awful procedure. And then he tells me what really bothers when you brand him. So I found that just ludicrous, but he's a super smart guy, and his client is Amazon. So he's like the golden child of his firm because he is keeping Amazon in and keeping their register running. All right, Rob, which guy do you want to talk about? Again, first names only and only positive stuff, only the good stuff.
Oh, man. Oh, CJ, I think we should leave this to you. I mean,
how about recent settlements?
All right. All right, Anthony, let's talk about some recent settlements.
Well, I was gonna just say that Rob has been even if, like you said, you and John have been gone to bat for each other against each other. It's been cordial. Exactly. It doesn't. Being strong in other cases doesn't hurt any of our clients because we were just able to settle one, amicably with another one of their associates. I think the name is Jordan. But I guess I was just bringing up that, it's nothing bad to say about anybody, that we're able to kind of still respectfully push for every case, and that where Amazon is wrong, they do concede sometimes.
Well, I got to tell you, my first experience with Jordan, it was nothing but positive. We won the case. And if any of you have ever met former Amazon staff, Amazonians, they tend to be very, very structured. Amazon has built in this culture where you really go from A to Z in 2 pages or less. This whole thing about meetings should never be more than enough people that you can feed with 2 pizzas. It's entirely true. And Jordan over there is also a very, very structured guy. So when the case is something you can skate around the structure in a persuasive way, that's a great way of dealing with cases with Jordan. Rob, what do you want to add to the conversation? We're getting close to wrapping up our very, very first webinar.
I mean, yeah, the recent settlements have been great. Aside from when we have to battle each other, there's also always opportunity to get along with everybody. Jamie is another attorney over there who I couldn't say anything bad about. Has been relatively easy to work with. He might not be as detail oriented as the rest of his colleagues, but he's definitely someone who leaves the door open for communication and answers me when I reach out. So everybody there is okay to work with. Everybody we do our best to get along with, but we like to consider ourselves peacemakers, but sometimes making peace requires going to war. So that's how we handle it.
Let me go back to Jamie. Jamie, again, we're not using last names, and we're going to try and stay positive, Rob. Okay, we're going to try and stay positive. Jamie is probably one of the smartest lawyers I've ever met. Just one of those super intellectual guys, super bright. And he tends to handle the cases that are a little more like technical. So we know in the case assigned to Jamie, we're going to approach it a bit differently. And this is what helps. Like, we're not talking about Amazon's lawyers' personalities to bash them in any way, just to let you know that we have learned who these people are and how to work best with them in order to win our cases. So Jamie is a super intellectual person, which means I'm going to handle the case differently than I'm going toe to toe with John, who's more of a trial lawyer. There's also a lawyer. He's also incredibly zealous. All right. He's the most zealous lawyer over there. And his name is also Rob or Robbie. Very smart guy, super zealous. And we could sometimes use his zealousness and flip the tables on in front of an arbitrator, because he'll fight every point. And sometimes the strategy is let him fight. And we just lay low until the real important issue comes back. And you kind of show the ridiculousness, because Amazon is not always right. They might be right on a whole lot of points in any given case, but this is all strategy, okay? This is all persuasiveness. So those are some of the personalities of the lawyers on the other side, John and Robbie and Jamie and Amanda, okay? And I think as sellers, you need to know when you're going into these things who we are, okay, and how we can help you, and also that we know who's on the other side. So in closing, Anthony, is there anything you want to add right now before we wrap up our very first webinar? And again, please, if there are any issues, if we spoke over each other, please stick with us. It was our first shot. This is our first webinar podcast ever.
No, I think we covered the arbitration process pretty well. The big things, go Google and read the BSA now. If you're a seller,
Read it.
you got to read it. You have to self-educate. I mean, and just know that, you know, you never want to have to arbitrate, but even if it's an uphill battle, if that risk is worth it, don't be afraid to take that calculated risk. But there's a lot of things you can do before and during it. But, you know, read the BSA. It's everything that you could possibly do. You got to know your options.
Rob, anything you want to say in closing?
That's all, folks.
All right. I just want to add one thing that Anthony touched upon, which is the arbitration is the thing of last resort. And so far, out of all the arbitrations we've handled, on a positive note about Amazon, we've never retaliate at all. Win, lose, draw. They have to cut a check. They have to reinstate. They followed the order, and they have not struck back. You know, it doesn't mean someone's not going to be the first one they retaliate against. But so far, Amazon has been a very honorable company in doing exactly what they've been ordered to do when they lose and not retaliating at all. Okay, so thank you very much for watching or listening to our first webinar. We're going to post this very soon. It also should be available both audio and video. And if you've watched any of my videos at the very end, I don't self-promote, but I do promote something, okay? If you're shopping on Amazon, which most of us do, use the Amazon Smiles program, okay? Amazon Smiles, if you don't know it, Google it. What it does, lets you shop, and at no cost to the buyer, at no cost to the seller, Amazon will kick back a small portion of the sale to charity, okay? Our charity, the firm of our charity is called the Ty Lewis Campbell Foundation. Ty Lewis Campbell. Ty was 3 years old and he was diagnosed with a very aggressive form of brain cancer. He passed away just before his 5th birthday after 2 horrendous years. And I know when I was going through my divorce and my daughter was we were going through the family, like, you know, imploding, we would bring toys and leave them on Ty's doorstep. Unfortunately, Ty passed away, and his dad, Lou, and his incredible mom, Cindy, turned this awful tragedy into triumph and created this foundation that does nothing but raise money to find better treatments and, God willing, a cure for pediatric cancer. So please, Amazon Smiles program, and please pick the Ty Lewis Campbell Foundation, and thank you for joining us.
Awesome.
Thank you.
Thank you, guys.